Hello, I'm Rosemary Andolino, Commissioner of the City of Chicago Department of Aviation. Under the leadership of Mayor Richard M. Daley, the City of Chicago has become a world-class city, a global city. The Mayor has also set high expectations for us to conform to the highest ethical standards of performance. He has placed his trust in us to maintain a commitment to serve the public and to place their interests first. That is our commitment and our mandate as public servants. Personally, I consider it a privilege to serve the City of Chicago and its citizens. The following video provides an overview of the city's ethics standards and conduct for the Chicago Department of Aviation and the O'Hare Modernization Programs, city employees, as well as contractors and vendors that do business with us. As you will see in the video, the city's ethic ordinance, as established by the Chicago Board of Ethics, clearly defines guidelines with regards to gifts, employment of relatives, prohibited conduct, contract inducements, lobbyist regulations, restrictions on current and former city employees and officials, and limitation on campaign contributions. The Department of Aviation's ethics policies include additional guidelines, most notably its zero-gift policy, which will be explained further during the workshop presented in this video. Because the nuances of the ethics policy can sometimes appear complicated, this training video has been developed to be as clear and concise as possible. The workshop is intended to help you recognize potential ethics issues on your own and provide guidance on who to contact for expert advice. Our goal is to make our department's conduct completely transparent and to discourage and prevent conflicts of interest or even the appearance of a conflict of interest. On behalf of the City of Chicago and the Chicago Department of Aviation, I want to thank you for your continued hard work and commitment to maintaining the highest ethical standards. I trust you will find this video to be informative and enlightening, and I appreciate your close attention. Thank you.
I'm Steve Berlin, the Executive Director at the City's Board of Ethics. The first thing I want to do is talk to you a little bit about who the Board of Ethics is and what we do. The Board of Ethics is a small city agency, small meaning that we have 7 full-time employees and we have a board that's appointed by the mayor and confirmed by the City Council. They serve without compensation. 4 members of the board, although by statute, by law, we could have up to 7. My position as Executive Director is also appointed by the mayor with confirmation of City Council. Our board is independent, which means that they can be removed only for cause, which basically means high crimes or misdemeanors. The board has been around since 1987, and that's when the City Council passed the first version of the city's governmental ethics ordinance. And that's the main ordinance that I'll talk about this morning. That's the ordinance that my office administers, enforces, and interprets. And basically, the ordinance gives my agency 4 key responsibilities. The first responsibility, and I would say the one that we are most likely to come into contact with other city officials and city employees and city vendors, such as all of you, on, would be advice and guidance. The Board of Ethics is authorized to interpret the governmental ethics ordinance and to give advice and guidance that is confidential. And that means essentially that we answer the telephone, we receive email inquiries and walk-in inquiries. In an average year, we receive anywhere from 4,800 to 5,300 inquiries. Most of these inquiries come from city officials and city employees and city vendors, just like all of you. But a lot of them come from other government agencies. Sometimes they come from the press. Sometimes they come from the public. Most of the time of those 5,000 or so inquiries that we get every year, most of them are by telephone or by email, we're able to answer the inquiries right then and there because they're routine questions. Where can I get a copy of an ethics form? What's your address? That sort of thing. But we do get quite a few substantive questions, several thousand substantive questions, meaning, can I have an outside job with a vendor? I'm a city employee. I'm leaving my city service to take a job in the private sector after 20 years of city service. What are the obligations? What are the responsibilities? I'd like to serve on the board of directors of a not-for-profit organization, a 501c3. I'm a city employee. It's a delegate agency. It receives money from the city. Can I do that? Most of the time, as I say, we can answer the person's question right then and there. We have a legal staff that includes me and includes 2 other attorneys. We have daily meetings, and we're usually able to get a person an answer within 24 hours. We try to pride ourselves on customer service and getting back to people as quickly as possible. But maybe 100 times a year or so, the question is a question of first impression. And that means that we've never had the question before, essentially, and it requires interpretation of the law from the Board of Ethics. In which case, at the next board meeting, we will present the question to the Board of Ethics, and the Board of Ethics will render a formal written advisory opinion. And that formal advisory opinion is the definitive word on what the governmental ethics says about a particular question. Now, by law, all of those opinions and all of the advice and all the guidance that we give is confidential. And I want to stress that. We're the only agency in city service that has that confidentiality provision. And that means basically that if you pick up the phone and you call us, if you send us an email, and we respond to you, whether we respond to you orally or we respond to you in writing, the fact of your call, the nature of your question, and the nature of our answer is confidential as far as we are concerned. And there are no exceptions to that, except that in the law, when the board renders a formal written advisory opinion, we are required to make those opinions available to the public, but with names taken out. So that what you would see on our website, if you go to the City of Chicago's Board of Ethics website, you'll see a link that says advisory opinions, and there are approximately 560 of them that have been issued by the board in the 23 years of its existence, and you can search them by subject matter, but if you look at an opinion, you'll see that all the names have been taken out. Sometimes it's a little bit cumbersome to read, but that's by law, because we protect the identity of everybody in every department who's mentioned in that opinion, but it's available for the public so that people can see how we interpret this law. That's our bread and butter work, is giving confidential advice and confidential guidance. And if there's one takeaway this morning, hopefully there are quite a few, but one of the most important takeaways this morning is our phone number and our email address, because that's where you can call for confidential advice, ideally before you take a particular action rather than after you've taken a particular action. But you can get prospective advice from my office, and it's confidential. That's our bread and butter work. That's really what the Board of Ethics exists to do. The second basic function that we have is investigations and enforcement. To a very limited degree, we're an investigative agency. And that means that the governmental ethics ordinance, which we administer and interpret, gives us the authority to receive and investigate complaints that allege that persons subject to the law, which is city employees, city officials, and city contractors, have violated one or more provisions of the ethics or the campaign financing ordinance. We receive about 20 complaints every year. For whatever reason, I've been with the agency for 17 years, for whatever reason, most of the complaints that we get come in by the fax machine. I don't know why that is. I suppose that would be an interesting study. It just is what it is. But whenever a complaint comes into the office, we are required by our rules and regulations. Our board has rulemaking authority, and we do promulgate rules that are on our website. The legal staff of the agency is required to analyze the substance of that complaint and construe all inferences. In other words, assume everything is true. And then the question becomes, is it a violation of the ethics ordinance or the campaign financing ordinance if everything in this complaint would pan out to be true? We don't know if it's true because we haven't investigated it, but we assume if it's true, would it be a violation? If the answer is no, then we are required by law to dismiss the complaint. Most of the complaints that we receive in our office are dismissed for that reason. On the other hand, if everything in the complaint would pan out to be true, then we are required to recommend to the board that it commence an investigation. And when the board commences an investigation, it's done in-house by our legal staff, and the factual phase of an investigation usually takes about a month or two. And because we're so small, we're really not set up to do complicated investigations. But our investigations maybe will consist of an interview or a couple of interviews, and we will ask for written documents, and we will send out written questions. Then the board will hear all the evidence and make a determination, either that there has been a violation of the ethics ordinance or that there has been no violation. Obviously, those are the two choices. In either event, the board renders a written investigative report, not an opinion, but a written investigative report, which of course goes to the subject, and by law it goes to the city's law department. And the board can recommend appropriate sanctions. If it's a city official or a city employee, it could be up to and including removal from office or termination from employment. If it's a city contractor that's being investigated, one of the provisions in this law is that if a city contract has been entered into or is being performed in violation of the governmental ethics ordinance, then it could be terminated, it could be voided by the city. So the penalties for a city contractor could be loss of city contract rights or termination of the contract. In either event, though, the board will render a full-fledged investigative report, which will, of course, go to everybody who's involved, as well as the city's law department. But just as with our advice and our guidance, all complaints to the board and all investigations conducted by the board and the results of those investigations, whether a complaint was dismissed or it went to an investigation and the result of that investigation, it is all confidential by law. Okay? So that everything that we do is protected by confidentiality. Now, this law was written in the 1980s. It has not been changed since that time. Obviously, many of you are aware that within the state of Illinois, there's a push toward transparency. But as far as the Board of Ethics and the ethics ordinance is concerned, we enforce the law as it is written. And everything that we do is confidential, as far as advice and guidance, as far as complaints, as far as investigative work. But I want to stress one key thing about our investigative work. And that is that we are not set up to be an investigative agency primarily. In fact, most of the investigations that we do relate, unfortunately, to people, city employees and city officials who have failed to file their annual ethics forms on time. It's a shame that that happens, and my lawyers have to spend countless hours chasing people, but that's the way it is. We also do campaign financing investigations, which I'll talk about a little bit later. But we are not, by and large, set up to be primarily an investigative authority, an investigative agency. We have the authority to refer complaints. We do refer complaints, for example, to the Inspector General's office. We have the authority to refer complaints to any city agency that could conduct investigations, and we do that. But we are not primarily an investigative agency. And that means that our role is really educational and advisory. One of the reasons I'm here this morning, and I'm grateful to the department to allow me to come out here 4 times a year, is to advise people that it is better to pick up the phone and call my office before you take action rather than become the subject of a complaint that's filed by a coworker, that's filed by a competitor, that's filed by a member of the public with our office. Because if you call us in advance, then we will give you advice as to how to comply with the governmental ethics ordinance or the city's campaign financing ordinance. In fact, a couple months ago, one of my friends asked me, he said, Steve, how do you keep people ethical in the city? That's a big job. I said, well, I've heard that before. I've heard that for the 17 years that I've been with the city of Chicago. And the answer is, if people take the time to email us or pick up the phone and call us, then we will keep them ethical. Because that's really the best thing that we can do. And that's one of the reasons I'm grateful to be out here this morning to talk to everybody, is so that you know that we exist and you know that you can call us in confidence. Third basic function that we have is education. Obviously, one of the reasons I'm here is because one of the charges of the Board of Ethics is to educate as many people as possible about the standards that are in the ethics ordinance and the campaign financing ordinance and how to comply with them. Education is a critical part of what we do. Those of you who are city employees know that we have an annual online ethics training program that's required by law of all city employees and city aldermen. That's about 36,000 people each year that complete our online ethics training program. We also have face-to-face ethics training for high-level senior executive management employees of the city of Chicago. That's about 10% of the city's workforce. And we also do classes for visiting foreign delegations, which is always fun, and we do classes for departments at their request, such as this. Education is a critical part of what we do because it's key to get the word out, and it's key that people understand they can call us before they take action. The last thing that we do is that we regulate people, which means that we collect public disclosure forms. And our public disclosure forms are collected from lobbyists, and I'll talk about who lobbyists are and what, if any, responsibilities and obligations you have. Some of you may in fact be registered lobbyists with the Board of Ethics, or you may work for companies that have registered lobbyists on behalf of us. Others of you probably deal with lobbyists on a periodic basis behind your city desk. I'll talk about what the responsibilities and obligations are of both sides a little bit later on this morning. And we also collect ethics forms from certain city officials and certain city employees. Those of you who are city employees whose salary level is at 76,450 for 2009, should have filed with us. In fact, everybody from the Department of Aviation did file with us on time a 2009 ethics statement, a statement of financial interests, which has 12 questions. Those forms are kept on file in my office for 7 years. It has 12 questions. We keep them for 7 years. And then after 7 years, we destroy them. But during that 7-year period, they are open for public inspection. They're open for press inspection, etc. The idea behind there is that sunshine is said to be the best disinfectant. So these are conflict of interest statements where people who work for the city tell the world who their outside employers, if any, were, what gifts, if any, they have received, which doesn't apply to people sitting in this room, and what outside business ownership interests they have, etc. The idea being to ferret out conflicts of interest. That's a brief overview of what my office does. One thing I do want to ask or do want to request is that if you've got questions, I know this is a very large group. If you do have questions, please raise your hand. Speak up loudly, and I will be happy to answer your question, and I'll probably repeat it for everybody else. So even though this is a very large group, don't be shy. And the risk that you take if you don't ask questions is I'm going to babble all morning. So please ask me as many questions as you wish. That's what makes these classes fun. What I'd like to do at this point is I would like to show you our training video that was developed about a year ago specifically for vendors and contractors of the city. It lasts about 5 minutes. And then when that's over, we'll see if there's any questions. And if not, I'll move into the material topic by topic.
Hello, I'm Jamie Rhee, Chief Procurement Officer for the City of Chicago. Thank you for taking time to learn about doing business with the city. As a potential or current vendor, you should be aware of the rules and ordinances that govern the city's contracting processes. The procedures and regulations you will learn about in this video serve to ensure that the City of Chicago maintains a procurement process that is fair, transparent, and accessible. Thank you again for your interest in doing business with the city. We look forward to working with you in the future.
Hi, I'm Gene Honda. The important information that we cover here will help you to understand the ethics rules and to prepare to comply with them. The rules are pretty straightforward, so let's go through them one by one. Let's first talk about some of the rules on gifts. City law limits the gifts any person can give or offer to give to a city official, employee, contractor, or candidate for elected city office. The law says you can't give them any cash gift or any anonymous gift. And you can't give any gift based on a mutual understanding that the city employees or officials' actions or decisions will be affected in any way by your gift. The law also says you cannot give a gift to any city official or employee who can affect your city business, except for an occasional non-monetary gift of nominal value. And you cannot give more than $100 in gifts to such a city official or employee in a calendar year. However, any gift, no matter how nominal, which could create even an appearance of impropriety, is strongly discouraged. And by the way, the restrictions on gifts to city employees and officials also apply to their spouses and minor children. And some departments may prohibit their employees from accepting any gifts from vendors or would-be vendors. So be sure you know the department's rules too. City law also says that any contract obtained, entered into, or performed in violation of the ethics laws can be canceled by the city. So it's important for you to understand the ways in which not only your conduct, but the conduct of others can affect your ability to obtain and keep a city contract. First, if your business is wholly or partly owned by a city employee or elected official, city employees and elected officials cannot have financial interest in any contract, work, or business of the city. Essentially, this means that a city employee or elected official cannot have an ownership interest in any city contract if that interest has a cost or present value of $5,000 or more, or if that interest entitles the owner to receive more than $2,500 a year. These restrictions apply to appointed officials as well, unless the contract is wholly unrelated to what they do for the city. If an employee's or official's interest in any city contract exceeds these limits, the contract can be canceled by the city. Second, if you hire a city employee or official, city law prohibits that person from giving you advice or assistance on a city contract unless the advice is wholly unrelated to his or her city duties. Third, if you hire a former city employee or official, that person cannot assist you on a city contract if, while working for the city, he or she personally helped to formulate or supervise that contract. Nor can that person, for 1 year after leaving city service, assist you on any matters involving the city if, while with the city, he or she was personally and substantially involved in the same or similar matters. And if you employ or contract with a relative of a city official or employee to work on a city contract, the official or employee cannot oversee or supervise your city contracts. The city also has laws that regulate lobbying. If you lobby the city or hire a lobbyist to assist you in seeking a city contract, the person who lobbies must register with the city. And if you employ or retain an unregistered lobbyist, or hire a lobbyist on a contingency basis, you can be fined up to $2,000 a day. City law also limits the type and amount of campaign contributions that can be made to an elected official or candidate for elected city office. For example, cash contributions cannot exceed $250. Anonymous contributions, or those made in someone else's name, are unlawful. And there is also a $1,500 annual limit on the amount of money registered lobbyists and persons doing business or seeking to do business with the city or any of its sister agencies can contribute to any candidate or elected official of the city.
Hi, I'm Steve Berlin, the Acting Executive Director of the City of Chicago's Board of Ethics. Thanks for watching. If at any time, after watching this video or taking the online ethics training quiz that we have for vendors, you have any questions, please call the Board of Ethics at 744-9660 or check our website at cityofchicago.org. Thank you. Thanks. That was taped last fall, and my title has changed, but that's okay. The substance of that video remains current. Does anybody have questions about matters that were raised in the video at all? Okay, what I'd like to do is cover a couple of key topics here. The first one is, just want to remind everybody what Ellen had said and underscore what Ellen had said before, which is gifts. I will say that the Board of Ethics receives more calls on gifts than any other substantive topic in the ethics ordinance aside from ethics forms each year. And there's a reason for that, and that's because the world revolves, or some of the business world revolves around gift giving. Now that is not, or should not be, an issue for anybody in this room, because as Ellen said, the Department of Aviation /OMP has issued a no-gift policy. And there are several departments in city service that has that. And in fact, as the video mentions, there is a particular provision of the ethics ordinance that authorizes any city department to have rules and to adopt rules or regulations that are stricter than what's contained in this ordinance. The ethics ordinance can be looked at as a floor, not a ceiling, okay? In fact, what we say is that the ethics ordinance really is the floor, and if you really want the ceiling, what you should do is comply with the spirit of the law as well. It's a law, but it also has aspirations. One of the things that the department has done here is to add that ceiling. In other words, there shall be no gifts at all. So keep that in mind. If there are ever questions about interpretation of that policy, Ellen is the person to contact, and if the department has questions, they can seek advice from us. But it makes it easy for all of you. No gifts. And that is not the case for other city officials and city employees, which is why we have so many questions. But for you, it is easy. So just keep that in mind. No gifts offered, no gifts accepted. What I want to talk about briefly also is something that the video mentions, which is employment of relatives, or nepotism. We get quite a few questions about employment of relatives every year from city officials and city employees. There are two key provisions that everybody should be aware of. The first one really deals with internal city matters, and it says that no city official or city employee can supervise a relative or domestic partner of theirs on their city job. And that means that if you have one relative who's a deputy commissioner or an assistant commissioner, and you have another relative who works in the same city department that is a laborer or a foreman, for example, and they're in the same chain of command, it's not an automatic violation, but it means that the person in the supervisory position would have to delegate all employment-related authority to another person in the department who is not a relative of the other individual, the foreman, the laborer, etc. Sometimes because of the size of a city bureau, that's impossible, and there has to be a transfer that's made. But what it means then is that the person in the supervisory position could not make daily work assignments with respect to his or her relative, could not sign off or approve vacation time, raises, promotions, sick time, anything that would constitute employment supervision. That would have to be very carefully delegated to somebody else in the department who is not a relative of the other person. And if a department cannot make that accommodation, then there would have to be a transfer of either of those employees to another bureau or to another department. That's what the law requires. The second provision in the nepotism section of the law is really the one that deals with vendors. And what that says is that no city official or city employee may exercise contract management authority with respect to any city contract that is being performed by a company or a person that employs one of their relatives or domestic partners, or that contracts with one of their relatives or domestic partners. Now that sounds complicated, but what it really means is that city officials and city employees cannot work on contracts with companies that hire their brothers, their sisters, their sons, their daughters, their aunts, their uncles. That's really what it means. Contract management authority is a defined term in the law, and it means pretty much what you would think it means. It means if a city employee is responsible or substantially involved in negotiating a city contract, in drafting the scope of services for a request for proposals, an RFP, or a request for qualifications, an RFQ, if they find out that one of the bidders or one of the companies that's performing that contract or that bids on that contract employs their sister, regardless of whether they employ their sister as a senior vice president or they employ their sister as an accountant out at the company's Glendale, California office. Either way, now the city employee would have a responsibility to go to his or her commissioner or his or her deputy and say, I have a potential conflict of interest here. I would have to be screened off, and the department would then have to screen that city employee off from working on that contract. Okay? It doesn't mean that the company that employs the sister cannot have a city contract, because the restriction is not on the contractor. The restriction is on the city employee. He or she may not exercise management authority over that contract. So it means that you'd have to have a screening arrangement, what's known in the trade as an ethical screening arrangement, whereby the city employee is screened off from any work with respect to that contractor or that vendor. That's what the law requires. So that's nepotism. I'd say we get about 50 or 60 questions each year with respect to employment of relatives, with respect to nepotism. And if you have questions about that, I can take them, after class. You can call me, you can email me, etc. I want to talk a little bit about relationships with elected officials of the city and loans to city officials and city employees. This is a provision in the law. It's section 111. I'm not going to bore you too much with section numbers, which are of interest to me because I'm a lawyer and I'm a geek. But as far as you're all concerned, what it means is that there cannot be any loans from any city contractor or any city vendor to any city official or city employee, or to their spouse or to their domestic partner, or to any business which the employee or the official or the spouse or domestic partner owns. In other words, no sweetheart loan deals between city people, city officials and city employees and their outside companies, and city vendors. The exception here is if the city vendor is a financial lending institution, i.e. a bank. Luckily, there still are some banks that are in business, and some of them actually do business with the city. Chase, Northern Trust, Bank of America, they come to mind. It means that if you're a city official or a city employee, you can have your mortgage on your house with Northern Trust. you can receive an outside business loan from Chase. But what it means for those of you who are vendors or contractors, unless you're a bank, and I don't think anybody sitting in this room is a bank or a financial lending institution, you cannot make loans to any city official or city employee, regardless of amount, regardless of interest rate. Otherwise, you'd be in violation of the governmental ethics ordinance. Or either to the employee or to the official or to any business which either they or their spouse or domestic partners own. So no loans between city vendors and city employees, city officials, their spouses, and their domestic partners. That's what that provision means. The exception is for financial lending institutions and market rate loans. So the other way that this applies is if any of your companies have a business relationship with an elected official. If they do, then your company would be in violation of the governmental ethics ordinance, because what the law says is that any person or any company who has a business relationship with an elected official, what does that mean? A business relationship means any contract or business dealing with an elected city official, any of the 53 elected city officials, the mayor, the clerk, the treasurer, or any of the 50 aldermen. Actually, currently we have 49 aldermen. We have a vacancy in the 26th ward. But with any elected official of the city, if your company is contractually obligated to pay an elected official or a business which he or she owns $2,500 or more in compensation a year, then you cannot be a city contractor. It means that, for example, your companies could not hire a law firm of which an alderman might be a partner. Because if you do, then you'd have to give up your city contract. That's really what it means. So the prohibited conduct provision says that no city contractor can have a business relationship with an elected official, otherwise their contract is in jeopardy. And a business relationship means any contractual relationship whereby the business or the city contractor is contractually obligated to pay $2,500 or more in compensation, either to the elected official or to a business that the elected official owns. So those are two kind of quirky prohibitions in the governmental ethics ordinance. We don't get many questions about loans or about this business relationship aspect. They're very complicated in many ways, but they are on the books. And if there's ever a question about one of your companies hiring law firms of which city elected officials may be partners or of counsel, for example, or hiring companies that are affiliated with or potentially owned by city elected officials or their husbands or their wives or their domestic partners, pick up the phone, give my office a call. Don't take the chance that your city contract might be jeopardized. I want to talk a little bit about lobbyists and lobbying. This is one of the, we're moving into the confusing aspects of the law, which I'm going to try to unconfuse people on. The video mentions lobbyists. Who is a lobbyist, and what are lobbyists required to do? What can they not do? A lobbyist, the city of Chicago defines lobbyist very broadly as any person who represents another, potentially an employer or a client of theirs, to influence any city legislative or administrative action. Legislative action means anything that could be presented to the city council. A lot of things are presented to the city council. A lot of things that involve the Department of Aviation and OMP are presented to the city council. Those are legislative matters. What is an administrative matter? Basically, an administrative matter is any decision that's made by a city official or a city employee with respect to procurement matters, contract matters, matters involving concession agreements out at the airports, bond matters, real estate sales, real estate leases, real estate zoning matters, tax increment fine. Basically, any decision that's made by a city official or a city employee is an administrative matter. Well, what does that mean? What does it mean when your company comes in and meets with somebody from the Department of Aviation? Are they lobbying? The short answer is that if your company is seeking a city contract and is not responding to an already existing RFP, request for proposals, or RFQ, request for qualifications, then yes, your company is lobbying. What does that mean? If your company is lobbying, then what it needs to do, or somebody needs to do from your company, particularly the people who are interacting with the city folks, are going to have to call the Board of Ethics and register as a lobbyist so that they can continue to seek that contract, they can continue to meet as much as necessary with city officials and city employees and try to influence their judgments. There's nothing wrong with lobbying. There's nothing wrong with meeting with city officials and city employees and trying to influence their judgments. That's the way business is conducted, and that's the way business ought to be conducted. It just means that if you are, unless you're responding to an RFP or an RFQ, and you are trying to influence the city's judgments as to procurement matters, as to contract matters, not in terms of performing an existing contract, but in terms of seeking additional contracts or contract modifications, then you'll have to register as a lobbyist with the Board of Ethics, which means that you call us up, you fill out an annual registration form, you got to pay a $200 per year per lobbyist fee, and then every January 20th and every July 20th you file lobbying activity reports which show who you've lobbied, a brief description of the actions on which you've lobbied, and what gifts, if any, of course that would not apply here, but that does apply to lobbyists, what gifts, if any, you've given to city officials and city employees. So lobbyist basically means anybody, unless it's pursuant to an existing contract, anybody who meets with the city of Chicago or its officials or employees to try to influence policy matters, to try to procure a contract for which an RFP or RFQ is not already issued, or tries to influence the city's judgments as to potential changes in the municipal code. Right now we have 600 registered lobbyists with the Board of Ethics. Most of them are law firms. They are public relations employees of the large utility companies. They are also public relations firms, etc. And they represent about 1,200 different clients. So one of the proposals that's before the City Council right now is, and I think this is a very good idea, of course, is that all registered lobbyists would be required to take an annual ethics training course too. I think that's a very nice thing because it gives my office a little bit more work, but more importantly what it does is it trains lobbyists as to the same restrictions that we're talking about here. Pardon?
I have a question.
Yes, please.
You said if the RFP is already issued, you don't have to go register.
That's correct. The question was, if the RFP or the RFQ has already been issued, then you do not have to register. And that is an activity that is carved out of the definition of a lobbyist. A person who is responding to an existing RFP or RFQ is not required to register as a lobbyist by that activity. The other exemption, which will not apply to people in this room, is that as a matter of policy, as a matter of law, not-for-profit organizations and their officers, their staff members, and their board members are not required to register as lobbyists either. If a not-for-profit has a, quote, hired gun, unquote, if they hire a law firm at the law firm's regular or even reduced rates to lobby on behalf of the city, then the law firm would still have to register. But a not-for-profit organization and its employees, its board members, its staff members, they are exempt from registration as a lobbyist. So not all cities have provisions like that. That's just the way the city of Chicago cuts it. So now, what are the obligations of city officials and city employees with respect to dealing with lobbyists? There really aren't any. Even if a person is not yet a registered lobbyist and you are a city official or city employee who's talking to that person and you spend 45 minutes talking to that person, neither of you are in violation of the law. Because if the person's not yet registered and they have just engaged in lobbying activity, they have 5 days to register with the Board of Ethics. And likewise, if you're a city official or city employee, you are not prohibited from talking to somebody, even if they're lobbying you and they're not yet registered. You're not required to make them register. Whatever penalties there are for unregistered lobbying activity would ultimately be imposed upon the lobbyist, him or her or itself. And what it means is that any contract that is entered into based in part on unregistered lobbying activity is voidable by the city. The city could cancel the contract. And if a lobbyist, after receiving a series of certified mailings from my office, fails to register, in other words, blows us off, then the Board of Ethics has the authority to fine those people up to $2,000 per day. Frankly, those are pretty substantial fines. They could add up pretty quickly. But the key here is that if you're a city official or city employee, what we advise people, the best practice for you to do if you're a city person, is when you see somebody who's coming in and you suspect that they're lobbying you, just to say, look, I don't work for the Board of Ethics, but don't embarrass either of us. If you're lobbying, which you might be just do us both a favor after you leave here this morning and call the Board of Ethics for advice and let them figure out, in other words, let my office figure out whether that person in fact engaged in lobbying, whether they should register. And we'll give the person a ruling. It's really as simple as that. So bottom line here is that if there's ever a question, again, like so many things, pick up the phone, don't be shy, give my office a call. So, yes, please.
If somebody's a vendor or distributor or manufacturer of a product and he calls a city employee and wants to present that product to the city, that would be considered lobbying?
That's a very good question. In fact, that's a question that comes up with a lot of the large line departments, such as aviation. And here's what we say. As a technical matter, yes, that is lobbying. But what we tell the city people and what we would tell the company is, for that first meeting, there's no reason for somebody to register in order to make that first meeting. But if the city's interested and they want to take it to the next level and they want to have a second or a third meeting, and ultimately it's going to lead to an RFP or an RFQ or maybe a sole source contract, at that point, once it gets taken to the next level, then the company ought to register as a lobbyist, or it ought to have its main city contact register as a lobbyist.
Now, if the city solicits that person and said, wants information about a product, does that person need to register, or is it that person basically just...
the fact that the city solicits it doesn't actually make a legal difference, because the reasoning behind the lobbying provisions is transparency and that the public has a right to know who's dealing with the city. So the fact that the city solicits it wouldn't take it out of the lobbying restrictions. But again, though, the first meeting is one where both the city and the company are, as they say, doing the dance, and they're both seeing if there's a possibility of moving forward. If there's no possibility of moving forward, in other words, the city people say, nice product, we just don't have the money, it's not right for us at this time, we'll talk to you again in 3 years or whatever, by which time the technology, of course, would be 3 years obsolete, but that's beside the point. Then there's no reason to register as a lobbyist. And so then what we say is that what triggers it is once the city people become interested and they want to take it to the next level, then at that point, the registration is really triggered. And then at that point, the main city contact for the company ought to call us and register.
In the process of doing the discussion or doing the dance for an existing RFP, RFQ, when somebody is trying to influence a city official regarding their viability to, receive that RFP, RFQ, what's allowed? What's that person allowed to do? Can you
All right, now.
Lunch?
Okay.
Can you go to ball games?
That's a very good question.
Football games?
Well, the answer, if it's the Department of Aviation, is no gifts, okay? Now, lunch is a gift, unless the city people pay their own way, okay? Now, what you raise is an interesting question. Let's say it's a sporting event and the city person pays his or her own way. Mm-hmm. That could be a very complex issue when you talk about face value of tickets, and maybe it's a playoff game. Let's hope it's a playoff game for one of our baseball teams, or maybe it's a playoff game for the Bears or the Bulls. Well, everybody knows this gets into an issue it's a hot issue ethics-wide across the country. Is how do you value the ability to buy a ticket at face value? That itself, that access to be able to buy a playoff ticket at face value is worth a lot of money. All you have to do is go on eBay and you see that people are out there donating vital organs for it's a crazy world. They'll sell their vital organs for a playoff ticket. That's kind of an open issue. And so what I would say is, in order to avoid us getting into that issue, I would say that lunches, as long as everybody pays their own way, we don't consider those to be gifts. That's the way business is done. The same thing would be true of golf, as long as everybody pays their own way. They pay greens fees, they pay food, they pay drink. Everybody pays their own way, and no gift, nothing is exchanged in terms of one person paying for another, then we do not interpret that as gifts.
So if you're in a group, basically, and there's only one city employee, he'd have to pay his.
That's correct.
Everybody else gets a free meal.
Well, now you're getting into. No, wait a minute. No, I didn't say that. Because I'm not. Because it depends on. Now you're getting into the office's gift policy. Okay. So, and that's something that you'd have to take up with Ellen.
Ellen, okay, fine.
Okay? So I wouldn't say everybody else gets a free meal. Probably the best thing to do is that everybody pays their own way. If you're dealing with a no-gift policy, that would be my recommendation.
That's a business lunch.
Yeah.
Basically, it should be everybody pays their own.
That's right. Everybody pays their own. That would be my recommendation here.
Now, if it's perceived as something personal, some type of personal event.
Well, in other words, it's a gift, is what you're really saying. Even a lunch is a gift. Even a cup of Starbucks coffee that's worth, whatever it is, anywhere from $2.25 to $6.25, that's a gift as well. Okay? So as long as everybody pays their own way, then there's nothing in our ordinance that would prohibit social activities like that, as long as, no value is given from one to another. Yes?
I guess the other end on that, can the city official buy the lunch for everyone at the negotiations?
Out of his or her own pocket?
Out of her own.
Well, if it's an aviation person, again, you'd want to, that may be covered by the aviation policy. I would think that it would be.
Okay, fine.
So I would think the answer would be no. Yeah, that would be my answer. In other words, that would be a gift. As I understand the way DOA OMP interprets its policy, the answer to that would be no. Everybody pays their own way.
Okay, fine.
So I want to talk about a couple of restrictions that are imposed upon city officials and city employees that all of you as vendors, all of you who are vendors and contractors ought to be aware of. If, for example, you hire city officials or city employees to do part-time work for you on weekends, or you may have owners, hopefully you don't, but you may have owners that are city officials or city employees. What are the restrictions? Well, the first restriction is one that the video talks about, which is the money for advice provision, which says that no city official or city employee may be compensated or receive anything of value in exchange for giving advice or assistance on matters that relate to city business. Now, on one hand, that's an anti-bribery provision. But if bribery were involved, I can assure you that the Board of Ethics would be last in a line of agencies that were looking at the situation. But what it really is, from the standpoint of a conflicts of interest agency, is that what it says is that city officials and city employees cannot, so to speak, double dip. And they can't be compensated by a third party, a company, for example, an outside employer that they work for on weekends, for example, to do the same thing that the city already pays them to do. So that means that if those of you who are vendors or work for vendors or contractors, if you have city employees on your payroll and they work for you on weekends, obviously they work for you on their off time, they can't be doing things for you that are related to their city job. Okay, that's what this amounts to. In other words, they can't be paid for doing things that relate to their city job. In theory, you could hire me as long as I didn't advise you on ethics matters. I don't know why you would want to, because that's all I can really do. But that's really what this provision says, is that city officials and city employees cannot double dip, so to speak, and be paid by a third party to do the same thing that the city already pays them to do. The second provision here is the conflict of interest provision. In a real sense, the entire ethics ordinance and our entire agency is about conflicts of interest. But the term conflict of interest actually has a specific, relatively narrow meaning in our law. And what it means is that city officials and city employees cannot make or influence decisions that affect or benefit persons or matters in which they have an economic interest. An economic interest is any interest that's capable of being valued in money. A city employee who has an outside job, a permitted outside job, and by the way, city employees are allowed to have outside jobs unless their department says no. In other words, a city employee can have an outside job, but he or she needs his or her department head's permission in writing before engaging in outside employment. And it's within the discretion of the department head to say yes or no. It's also within the discretion of a department to institute a policy that says none of our employees can have outside employment. I'm actually subject to one of those provisions as a department head. That's promulgated by the mayor's office. But what it comes down to is that if you have city employees on your payroll, that in their city jobs they cannot make or try to influence any decisions that would affect your company. Now, that seems obvious enough. The most common way that we see conflict of interest questions are when city officials and city employees have outside employment, because when they have outside employment, they have an economic interest in their outside employer, and it means that their outside employer can have business with the city. They have to stay out of it. In other words, the legal term here is they have to recuse themselves. They have to stay out of the decision-making process absolutely and completely. And if those rules are abided by, then there's no conflict of interest. The other provision I want to talk about is one that the video mentions a little bit briefly, but it's an important prohibition. And this is the financial interest in city business prohibition. What this says is that no city official or city employee may have a financial interest in any city contract or city work or city business. Financial interest is a defined term that means any ownership interest that yields $2,500 or more in income per year, or that's worth $5,000 at cost or present value. What it means is that if those of you who work for or own companies that have city contracts or city subcontracts, it means that if you have any city officials or city employees who are partners of yours, who are owners or part owners of your company, then those city officials or city employees and your city contract may well be in violation of the law. It means that no city official or city employee can have a $5,000 or more ownership interest in a city contract. How do we figure that out? You take the gross amount of the city contract, or the gross amount of the combination of city contracts that a company has at any one time, and multiply it by the ownership percentage that the city official or city employee has in the company. And if that together yields a figure of $5,000 or more, then it's a violation of the law. Example, let's say that I own a computer supply company. I'm the executive director of the Board of Ethics, and let's say that I've received an exemption from the mayor's office pursuant to executive order that I can have outside employment. So I own this company, and my company's not even located in the city. My company's located out in the northwest suburbs. It's out in Arlington Heights. And I have a partner. And my partner's name is Adam, so we're A&B Computer Supply Company, and my partner's not a city official or city employee. And my partner hears that the city's Department of Information and Technology, DO-IT, is in short supply of a particular type of connector. And my partner has just received a shipment of 100,000 of these little plastic connectors from Singapore, and they're worth 50 cents a piece. And the city needs 50,000 of them. So it's a $25,000 contract, if my math is correct. Now, my partner says to me, Steve, I know you work for the city. I know this is going to be a problem for you if you work on this contract. Let me take care of all the bidding, and I'll talk with the people that do it. And if we ink the contract, you won't even know about it until it comes time for us to split our quarterly profits and our quarterly losses. Well, lo and behold, once my partner inks that contract with the city of Chicago, the contract is in violation of the law, and so am I. Why? Because you take my 50% ownership interest in this firm. And whether this firm is a corporation or limited liability company or a partnership or sub-S corp, whatever the tax and legal structure of the entity is irrelevant. I'm a 50% owner, and we share profits and losses 50-50. I'm an equal partner. I'm in violation of the law because now I have a $12,500 interest in this $25,000 city contract. Now, we may try to argue that, well, after we pay staff, and there's this depreciation, and there's this tax, and there's that tax, blah, 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 blah. It's actually worth less than $5,000 to each of the partners. No, Board of Ethics won't buy it because it would open up all manner of creative Enron type accounting. It is simply the gross or aggregate amount of the city contracts multiplied by the ownership percentage that the city employer official has in the company or in the entity. If it yields a figure of $5,000 or more, it's a violation, pure and simple. And that contract would be voidable by the city. So that means if you have owners that are city officials or city employees, you have to be extremely careful about this. Extremely careful, because these limitations are very severe. And every so often you read about a city official or a city employee who has an ownership interest in a company that's a city contractor or a city subcontractor. And in our environment, it's always page 1 or page 2 news, guaranteed. But that's what the ethics ordinance says. Last thing I want to talk about with respect to these kinds of restrictions are representation of other persons. This really applies to those of you who are city employees or city officials. There are no city officials by our definition in the office. Everybody here is a city employee or a city contractor or city vendor. City employees cannot represent, act as a spokesperson for any third party before any city department or city agency, unless they're doing their job. Now that means, I mentioned before that we get a lot of questions every year about, from city officials or city employees who would like to serve as on the board of directors of a not-for-profit, of a social service organization, a 501c3. Not prohibited by law, but it's just like it's a tightrope that the city person has to walk on, and there are certain restrictions. The key restriction is that even if it's a not-for-profit and they're not getting paid, it still applies. They can't act as a spokesperson for that outside entity before any other city department. So they can't pick up the phone and call their buddy in the Department of Family and Support Services and say, hey, I'm a director of this organization. It's a really good organization. They deserve that $10,000 grant. Please consider them. Can't do that. That's representation. They cannot sign documents that are submitted to the city. So if it's a grant application, if it's a contract application, an RFP, an RFQ, a modification document, a service order under a DUR contract, whatever it is, the city official or the city employee cannot sign that document on behalf of a third party. Now they can do their city job. So if their city job requires them to represent third parties before their department or other departments, there's no restriction. They just cannot act on behalf of a third party in any city agency unless they're doing their city job. And that's true whether they're paid or they're not paid, whether it's Boeing or it's a little mom and pop or it's a not-for-profit organization. It doesn't really matter. So that's the representation provision. What I want to talk about now are the restrictions on hiring city employees after they leave the city, or for those of you who are city employees, what are known as the revolving door or the post-employment provisions. Okay? Now these are probably, factually speaking, the most complicated provisions in the entire ethics ordinance. So what we tell people who are leaving the city is before you take a job with a contractor, with a vendor, especially a vendor or a contractor of your own former department or soon-to-be former department, pick up the phone, give the Board of Ethics a call. What it says is that for 1 year after he or she leaves the city, a former city employee or official cannot assist a new employer or a new client or represent a new employer or a new client on a business transaction that involves the city. So that's test number one, is that a business transaction that involves the city, if they were personally and substantially involved, that's the second part, in the subject matter of that business transaction. So you got three things. First, it's got to be a transaction with the city. Second, they have to have been personally and substantially involved in the subject matter of that transaction at any point during their city career. Okay? That's quite complicated. What's subject matter? Well, subject matter is a really funny beast. I've been at this for over 15 years, and subject matter varies from case to case to case. The only general rule I can say is the higher up a city official or city employees in terms of responsibility, the wider swath of subject matters he or she has been involved in their city career. It may mean certain aviation matters for 1 year. It may be any dealings out at either of the airports or both airports for 1 year. It may be a certain type of transaction for 1 year. It may be just one particular transaction for 1 year. It really just depends on the facts. Now, I want to stress one key thing here. The other prohibition, by the way, is you can't flip sides on a city contract if you're a city official or city employee. In other words, if you exercise management authority, you negotiate a city contract, you supervise the performance of a city contract, then you're permanently, meaning for the entire legal term of that contract, prohibited from assisting a new employer or a new client on that contract. Now, it says permanently, but what it means is for the legal term of that contract. Once that contract expires, let's say it's 3 years out, then there are no surviving prohibitions. You could work on a new contract, for example. Now, I want to stress one key thing about this, and that is that the law does not say that a former city employee or official cannot work for any particular company. A former city official or city employee can work for any company that he or she wishes to work for. Okay, that's not the way the provision works. The way the provision in the prohibition works is that it is a transaction-based or project-based or contract-based prohibition. And likewise, in other words, a person may have to be screened off from working on certain matters, either for a year or for 3 years or for 4 years, depending on the life of a contract. But they can still work for the company, and the key is that the company can still have those city dealings, provided there is an appropriate screen in place. In other words, provided that former city official or city employee does not assist the company in any way behind the scenes or in dealing with the city of Chicago on those matters. Okay? That's really what this means. In other words, the Board of Ethics recognizes ethical screening arrangements whereby a person can work for a company but would have to be screened off from, could not share or have information shared with that person on those particular contracts or matters, transactions. They can still receive their city, I mean not their city, they could still receive their compensation from the company, even if some of that compensation comes from those matters. Because the screen does not, it's not a financial screen, it's an activity screen. So they can't work on the matters, but they can still get paid whatever salary they're going to get paid, even if some of that salary comes from compensation from the city on those matters. Okay? Those are very complex prohibitions, factually speaking. They're very dense. So what I would advise is, if you're a company or you're a representative or a person who works for a city vendor and there's a departing city employee who wants to work for you and you want to hire that person, one of you pick up the phone, give my office a call, and we'll walk you through it and we'll, if necessary, give you an opinion in writing that tells the former employee what he or she can and cannot work on for a year or past a year. You don't want to jeopardize it, because what could happen is that your contract could be voided by the city if it turns out that somebody's working for you and working on a contract that he or she can't work on, or on a transaction that he or she can't work on. So, complicated provisions. What I want to talk about kind of last is campaign financing in elections and campaign contributions. Very, very, very hot topic in the state of Illinois right now. The first comment I want to make is that, as probably some of you know, maybe all of you know, the General Assembly, both houses of the General Assembly, have passed what is known as House Bill 7. I have probably spent a good week and a half of my life looking at House Bill 7 to see if it affects the city of Chicago. As I'm standing here, I can say that if the bill is signed by Governor Quinn, if and when it's signed by Governor Quinn, it will not affect what I say about the city's campaign financing ordinance for you, except in one or two ways that are actually less strict than what the city has. Let me talk first about the city's laws. The city has a campaign financing ordinance that has been in effect since 1987. What it does is it limits at $1,500 contributions that can be made to any of the elected officials of the city of Chicago or any of their official election committees in a reporting year. And a reporting year, for reasons that I've never been able to quite figure out, is a July 1st year, July 1st to June 30 year. It's not a calendar year. If you're a company that does business with the city, in other words, if you have $10,000 or more in business with the city of Chicago or any of its sister agencies like the Park District, like the Chicago Transit Authority, like the Chicago Public Schools or McPeer, then your company is limited to $1,500 in political contributions to any of the 53 elected city officials in any July 1st to June 30th year. That's the campaign financing ordinance in a nutshell. One key caveat here is that by executive order passed in 2005, the mayor's political committee does not accept any contributions from persons that are doing business with the city or their employees or their officers or their spouses or their domestic partners. And those people are prohibited from making contributions to the mayor's campaign. But as to the other 52 elected officials of the city, the 50 aldermen, now 49, but there'll be an appointment eventually, and the clerk and the treasurer, those limitations apply. Okay, so if you're doing business with the city, and a lot of you in this room either are employees of persons doing business with the city or are owners of persons doing business with the city, then those campaign contributions are applicable. Now, What if you are an employee of a company that's doing business with the city and you want to make an additional contribution? Let's say the company makes its $1,500 contribution in January. On January 1st, they make a contribution to Alderman X. You want to make an additional contribution to Alderman X. Can you do it? Is your contribution combined with the company's $1,500 contribution so that it might make you in violation of the law? The answer is, like so many things in the law, it depends. What does it depend on? It depends on whether you're reimbursed. Okay? If you're reimbursed for that contribution, either directly or indirectly through bonuses, through additional compensation, whatever it is, indirectly, then your contribution is combined with the company's, and it would have to be under $1,500 together. On the other hand, if you're not reimbursed in any way, shape, or form, then you can make an additional contribution. If your company's already maxed out at the $1,500 level, you can make an additional contribution. It's a fact-based question. And most of the campaign financing laws in this country have provisions like that. So it's a matter of, it would involve a technical investigation that would involve forensic accounting, et cetera. You have to figure out whether a person was indirectly reimbursed. Okay? But that's what the law says. Okay? That also applies to owners of companies. Owners of companies, as long as they are not, or shareholders of companies, as long as they are not reimbursed by the company, or they are not themselves individually doing business with the city, or are not a registered lobbyist. These contribution limitations are also imposed upon registered lobbyists. They are also imposed upon persons who are seeking to do business with the city. Seeking to do business with the city means that they have bid on contracts which have not yet been awarded, which, if awarded, would be $10,000 or more in a 12-month period. Or it means that they've had matters pending before the city council involving zoning, involving contract matters, involving bond matters. Certain matters are exempted. For example, the homeowner who wishes calls the alderman, something has to go before the city council with respect to an awning on their house. That's exempted. A handicap sticker, that's exempted. But any real estate matter, any matter that involves a city contract, any matter that involves bond or tax increment financing that goes before city council, any person who has those matters is subject to this $1,500 a year contribution limitation. Now, what are the things that the state law adds? Well, the state law adds, if it's not a state law yet, I should say. What does the potential state law add to it? One of the things that it will do, as I read it, and as I think it's a correct reading, is that natural persons, and a natural person is a lawyer's way of saying a bodily human being as opposed to a company. Any of us, for example, would be limited to $5,000 in contributions in any calendar year to any elected official in the state of Illinois, not of the state of Illinois, but in the state of Illinois, which would include the 53 elected city officials, $5,000 in a calendar year. Companies would be limited to $10,000 in contributions in a calendar year. Now, you realize that if you're a company, the city's limitations are already stricter. Okay, so you'd be subject to the stricter limitations of the city's city's campaign financing ordinance, not the state law. And likewise, for the first time ever, labor unions are covered. There's a contribution limitation that will be imposed upon labor unions. There will be contribution limitations that will be imposed upon PACs, or political action committees, that are formed by companies who themselves might be prohibited under federal law from making contributions, but their employees are not. Well, those employees' PACs, or those company PACs, will now for the first time, or would now for the first time, be subject to campaign contribution limitations. One other thing I should point out about the state law is that if and when the governor signs it, then it will not take effect, these limitations will not take effect until January 1st of 2011, a year and a half from now. One of the reasons for that is that the State Board of Elections, and my office deals with the State Board of Elections, very competent, very professional people. They're going to have to get their computer database, or their many computer databases, up to date, and that's going to take time and that's going to take money. And it was they who, among others, requested that there be a delay to the implementation of this law, because it's going to be a crushing burden on these people who live in Springfield and live in Chicago to get their databases up and running. Because any of you probably know, if you're interested, that you can search political contributions by going to the State Board of Elections website. Well, now that there are these limitations, et cetera, they're going to have to update their software, et cetera, et cetera. Those of us in government know how much work that takes, and they're breathing a sigh of relief on this one. So those are the campaign financing ordinance limitations. One thing also I should say about the city is, what are the penalties if a person exceeds the campaign contribution limitations? Let's say your company gives, inadvertently, whatever, gives $2,000 to Alderman so-and-so, and your company's doing business with the Department of Aviation. Is your contract going to be canceled? Are you going to be sued? Are you going to have to pay a big penalty? The answer is, under the city's law, that the remedy that we have is to require you to receive a reimbursement from that elected official. Okay? That's the remedy. So what my office does is, what my staff does is that we check all city contract records, we check all city council records, we receive records from the sister agencies like the Board of Ed and the Park District, and we make several databases of persons who are subject to these limitations. And then we review all of the forms that are on file with the State Board of Elections on their website. And then we go through 13 or 14 different checks. And when we determine that a person who is subject to the $1,500 limitations has exceeded them, then we take out an enforcement action. In other words, we do an investigation. And the results of that investigation do not by law invalidate the contract. But what it means is now the contributor is in violation and has to seek a refund and receive a refund from the campaign committee before we close out the case. That's the remedy. So, yes, question.
Is anything changing for city employees under any of the ethics rules?
Under our city rules?
For the state?
With respect to this, the only change is that currently there is no limitation on the amount of money that city officials or city employees may contribute, as long as it's not cash. In other words, if you write out a check to the elected official of your choice, under the state law, if the governor signs it, there will be a $5,000 limitation on political contributions to elected officials in a calendar year. So that will be, for the first time, I, for example, will be subject to those limitations, whereas I am not right now. To my knowledge, that's the only, having reviewed these laws, that's the only change that will affect us as city officials or city employees. In any of these bills that have been, these ethics reform bills that are adopted, there's no home rule preemption. What also will change, I should say, is the way that city departments conduct their Freedom of Information Act procedures and requests. That will change as well. So, and the city's law department actually has people that are looking at those changes, and they will be training everybody in the city about how those laws affect what they do. So that's our campaign contribution limitations. And yes, I'm sorry. Here we go.
This isn't for campaign contributions, though.
That's okay.
Am I right to assume that acceptance of an invitation to a contractor or a lobbyist holiday party constitutes a gift? And if so, is that now banned by?
Well, my reading is yes. Ellen, if I want to have my answer confirmed by Ellen.
You're the attorney here.
Well, I'm the attorney. I would say yes. If it were me, I would advise you that it's banned. The question, if you could repeat it.
Acceptance of an invitation to a holiday party, which is sponsored by either a contractor or a lobbyist, constitutes a gift, and if so, is that now banned for all Department of Aviation and NYPD employees?
Not banned. You can go. You need to pay your own way.
What about a labor union?
Doesn't matter. If you'd like to go,
So what constitutes paying your own way, though?
find out from the organization what the average cost is, and if it's $35, write them a check for $35.
That's right. And that's
certainly you can go. We're not saying you can't. You just can't accept a gift. And so that invitation would constitute a gift. Pay your own way. Same with Cubs tickets, anything else. Pay your own way.
Does everybody? If I could get everybody's attention, this is a very important point. I know that the question was up at the front, but those of you who are standing in the back need to know as well. The question was, if a person sitting in this room who's subject to the department's gift ban is invited to a lobbyist's holiday party, a party, the air show's coming up in a month and a half. There'll be lots of parties that have nice views of the air show. If you're invited, can you go? Is that a gift? The answer is it is a gift, but you can pay your own way. Okay? Now, if you don't know what the value is, you'll have to ask, and they'll give you a value. So that's what it really comes down to. If you pay your own way, it's not a gift. So now let me see if there are any other questions. If not, I'm going to conclude here by saying that, number one, I very much appreciate the opportunity to come out. Number two, my phone number, my agency's phone number is on the materials that you have, our email addresses as well. You pick up the phone, you call us, it's confidential, and you will get advice from us. And I encourage you to call us with whatever questions you have, because I've been in this business a long time, and there's no such thing as a stupid question. Okay? I thank you very much for your attention.